Respectfully urge you, my Lord, to find merit in this application and to grant the orders that are being sought. My Lord, my learned friend, Honorable Segona, I think wants to just wrap it up in a few minutes. Thank you, my Lord.
A prison's office can only detain on a valid warrant issued by a competent authority, in this case, court. Upon the demise of the General Court Martial, it is very clear that the power of the General Court Martial to order detention collapsed. And it collapsed in the presence of the Attorney General of the Republic of Uganda, who is the first respondent in this application. Whereas it is urged by the first respondent in the affidavit of Mr. George Karemera, paragraph 9, that the Supreme Court did not order release, there was actually no necessity to order release.
So, yeah, on that point.
Yes, my Lord.
So you are trying to bring in some words in the decree?
No, my Lord.
You're saying it was not necessary, but it said so in so many words. You are bringing in.
I am not even wanting to go there. I am only restating the position of the Constitution. Under the Constitution, liberty is guaranteed. Restriction must be justified, and that justification must be a lawful one. And in this particular case, the lawfulness would only be cemented on on a valid order of a court with competent jurisdiction. In the absence of it, there is no justification, and it is your power, my Lord, and duty to order freedom to be reinstated. Away from the Prisons Act, my Lord. Yes.
The Lord Mayor, my former teacher, are putting me under some weight that I should do it now. But I need to write it. Do I write it to me?
My Lord?
Can you address them?
Yes.
I can write it
Yes, my Lord. Yes, my Lord, now is contextual. And what we are saying by now is that upon conclusion of our submissions, the court be pleased to begin writing the release order. In the same realm of context, my Lord, I now propose to take you to the context of the Supreme Court's order of transfer, which has been misconstrued. My Lord, this must be looked at from the perspective of Article 120 of the Constitution. The Supreme Court did not order the Director of Public Prosecutions to take over, because that is barred by the Constitution, Article 120. In effect, the Supreme Court told the first respondent, if he's interested in any prosecution, to go and start de novo. Do a fresh investigation, a fresh complaint. What one would expect is the state to report to the nearest police station or post and report and start with the first information. Why? Because any warrant of court has an expiry date and tenure. Thank you. My Lord, with your permission, and I'm grateful, because the DPP cannot take over, the transfer order must be contextualized to mean, if you are interested, start a fresh complaint system. Go to the nearest police, report that these people are alleged to have committed offenses X. And when you do that, the DPP looks at the file, because the DPP even has the power to say this one does not merit, and drop it at that stage. I was taking you on the point that a warrant or detention order itself has a time limit. Bring back this person on this particular date. That is axiomatic. And the moment it expires, lawfulness ceases. In this particular case, the warrant of the defunct court-martial was actually in itself expiring on the 3rd day of February. They could not extend or even terminate because they had ceased to exist. And since that time, the lawfulness, if at least it had not collapsed on the 31st day of January, died or redied on 3rd. My Lord, to contextualize Article 120 and the decision of the Supreme Court, I would implore you, and we shall supply a copy, the decision of the East African Court of Appeal in Kagenyi versus Musiramo and another. Kagenyi versus Musiramo and another. 1968 East Africa, page 43. The gist is this: that a transfer is not even possible if the court originally had no jurisdiction. The decision of the Supreme Court, or even the Constitutional Court before, are to the effect that from the word go, the General Court-Martial had no power, had no jurisdiction. So there was nothing to transfer. That's why I want you to contextualize the decision of the Supreme Court. Finally, my Lord, on the question you did ask me, when we say that you be pleased to order now, the word normally used by lawyers is ex tempore of judgment. Oh, actually, I'll come back to this. The word is, it is usually used to describe an oral judgment, including reasons for judgment, given at the time of the hearing. That is the context of we propose and implore you to find pleasure in ordering release now. But this particular case of Kagenyi versus Musiramo was cited with approval in Rose Wanjiku Njau, Rose Wanjiku Njau versus Nicholson Philip and two others. Miscellaneous criminal application number 387 of 2012 by the Supreme Court of Kenya. To sum up, my Lord, in one sentence, the affidavit of Mr. George Karemera, which attaches a letter purportedly by the principal judge, and now you can see the bad faith, exchanged without reference to us, particularly those of us who went to the Supreme Court, does not place a lawful justification. It only talks about the administrative measures.
For the benefit of our media house,
Yes, my Lord.
just give the essence, because you have made reference to that later.
Yes, my Lord.
Essence of the honorable principal judge's letter. What is it in which state?
My Lord, in principle, the Honorable Principal Judge is communicating measures taken by the judiciary administratively to guide the process of moving these files away from the deceased court martial.
Let's bullet those measures. We can speak about 3 measures. We can bullet 4.
No, my Lord, the principal judge, the Honorable Principal Judge does not bullet those measures.
I'm talking about bulleting in our.
I'm avoiding the bulleting because I'll be reading into his letter, but I can read it. I have received rights to the Minister of Defense and Veteran Affairs and to the Director of Public Prosecutions. I have received the attached self-explanatory letter from the Honorable the Principal Judge, Justice, the Chief Justice, advising that files pending before the General Court Martial that were subject of judgment of the Supreme Court and in the captioned case be handed over to the Honorable Principal Judge for further management.
Bullet number 1, all files to go to.
Yes, yes. This therefore is to bring, yes, bring them to the Principal Judge. The next is, this is therefore to bring the advice to your attention for your appropriate coordinated actions.
Request for coordinated second.
Yes. And it is a letter dated the 6th February 2025. My Lord, even the Principal Judge's letter does not talk about the persons in custody. So it is not telling them continue with the detention. In other words, there is no single order of a lawful authority to detain. And it is that order which would have been the justification to restrict somebody's freedom. But let me ask a question and answer it. Thank you, my Lord. That's so gracious. On whose orders and under whose authority are the applicants in detention? Number 2, what is the criminal case number? The Supreme Court having said the prosecution ceases and with immediate effect by 31st. By fall of night 31st, the criminal case number for the General Court Martial ceased. The file could be there for investigation purposes. You and I could be, maybe not you, maybe I could be under investigation, my Lord. God forbid, you should not. We need you. So the question is, under what criminal case number? And detained until when? The last time we had a detention which is unlimited in duration was under the Public Safety Act. And that one collapsed with the coming into force of our constitutional regime. nobody can be detained indefinitely where there is no pending charge. That one will be a recipe for chaos in our country that anybody would detain. With that, my Lord, I can only say that let nobody drag the judiciary into this detention controversy of, say, relying on the order, the letter of the principal judge, an administrative letter. Very unfortunate.
Ironically, we cannot run away from being dragged in.
My Lord, if we are going to construe this as authority, the letter of the PJ, the next thing they will request you for a letter or granting a warrant to detain. And this was not a judicial letter. It was an administrative guidance to those persons, if they are still interested, prosecuting. Anything beyond that, my Lord, is a persecution, and I would invite you to put a hold on it. I so pray, my Lord.
No detention without trial.
My Lord, in a minute. My Lord, in 1 minute, Sam Mulindwa is my name. I'll just take you to Article 43 of the Constitution, my Lord, where you cannot detain anyone without trial. There is no ongoing trial, my Lord. Secondly, everything about that defunct General Court Martial was nullified. We cannot continue discussing putting something on nothing, my Lord.
Sir, an administrative letter. Not
And an administrative letter, whether by the Chief Justice or Principal Judge, cannot be such authority to take away this provision of the Constitution, my Lord. My Lord, further, my colleagues have submitted about Article 123, my Lord. If you look at 123B, my Lord.
This letter is not by PJ, so it is by judicial.
Actually, my Lord, to conclude on the letter,
Correction.
to correct my statement.
Our statement.
Our statement, when I look at this letter, it is by Chilio Wachiwanuka, not the PJ.
Actually, I apologize because I got a soft copy. I've only seen this physical copy, my Lord. I withdraw the reference to the PJ. It is the Attorney General. I only got a soft copy here.
My Lord, to conclude, reading Article 123B, even the DPP, my Lord,
When you say the letter is by
Chilio Wachiwanuka.
you mean the Honorable Attorney General.
Yes, my Lord. I told you-
Honorable by designation.
Honorable, my Lord, honorable by designation, but I knew that this court would take judicial notice of that, my Lord. Finally, my Lord, my reading of Article 123B actually precludes the DPP from even taking up any matters from the court-martial. It is very explicit. So most of the submission and the affidavit evidence that I've seen from the Attorney General is misconceived to the extent that it believes, the Attorney General believes someone can be in detention
On orders of
on orders of the Attorney General. My Lord, I join issues with my colleagues. Probably the rest will come in rejoinder. I'm obliged, my Lord.
Except I also wanted to express a little bit of concern. There's been a lot of exploring this court, particularly my Senate. I mean, we love it when people express their minds, but have to do it, not careless. Well, if I'm sure I die once and I will be buried twice, then you will not have gained anything. Probably your client's matter would have gone before another judge and it's an old man.
Yeah.
So, appeal to your audience. Now, does it really? Fortunately, I don't get the line that if you insult me, then I will get you on the bottom. I love people to. They can insult me, they want to get questions. Don't extend those insults. Straight. That's about housekeeping. I hope the point is made. Aging, can we listen? I wish aging how to see.
But you is not submitting, you can't see.
So aging, how you reply to the application?
Yes, my lord.
So you listen.
It is not that they have given us. They are subject to that.
Can you take us back point by point why you oppose the application?
My Lord, for record, again, I'm Johnson Akwera, and I'm a senior state attorney. My Lord, the application before you and us all is for habeas corpus. And for habeas corpus, it has elements that you must prove for it to be granted. One is that a person or the applicant was arrested. The said applicant is in detention, whether by state or anyone else. And that the detention is illegal. It's not in contention that the applicants were arrested and are in detention. The only issue is whether their detention is legal or illegal. And it is our contention that their detention is lawful. Your Lordship, we are not here to review the Supreme Court decision.
Okay, let me go slow. And I have to. So we are on the lawfulness.
Yes.
Point number one, bullet one is this court cannot review the Supreme Court decision.
Absolutely. And this is not the purpose of this application. The Land Honorable Chief Justice wrote about 200 pages, elaborate judgment, and it is self-explanatory. And it's straight law, my Lord, that any person who feels the application or the judgment of court cannot be construed in the way they feel it should, they apply the same court that issued it for clarification. My Lord, I'm not here to impose words, interpretations, because I'm not qualified to interpret the judgment of Supreme Court otherwise expressly given. Yes, and that's what I've said. I'm not here to interpret it otherwise as expressly given. Your Lordship, my boss, the Lord Mayor, who is part of this government, has elaborately read through the orders of Supreme Court. And if any case, he would be on my side defending government. He has elaborately read through the orders of court, dot by dot, word by word, and nowhere did the court say release. It only gave an order of transfer. transfer all the files which are pending before the court martial to courts of civil courts. And from our affidavit, deposed by Mr. George Karemera, the Land Commissioner of Civil Litigation, he has ably indicated to you steps taken from 31st of January when the judgment of Supreme Court was granted. I will not go through all the steps taken, but I can only take a brief that on 31st January, the Supreme Court indeed gave that judgment. Most importantly, the court ordered that all charges or ongoing criminal trials or pending trials before the court martial involving civilians must cease and be transferred to the ordinary courts of law with competent jurisdiction. To fulfill and implement the orders of court, on 3rd February, government commenced the implementation. We wrote to the Chief Justice, the Land Attorney General wrote to the Chief Justice requesting for a liaison contact on how transfer of files can be managed. On 4th February, the Chief Justice appointed the Principal Judge as the liaison contact and instructed him that all matters should be handled by himself.
So, if I now sit here trying to listen to these stories, I have superimposed myself on the role of the principal judge.
I'm coming to that, my lord. However, I didn't want it to push it into your mouth.
No, you can.
But since you have already said it, my lord, I take it, and that is the position of the respondent. And on 6th February, my lord, the Attorney General forwarded the Chief Justice's instructions to Minister of Defense and the Office of DPP. And on 13th February, that's when we received a decree from the Land Council for the applicants in the case of the respondent, in the case of Attorney General versus Kabaziguruka. And on 17th, the same was signed by both parties. My lord, Article 28 refers to fair hearing and a speedy trial. Speedy trial and fair hearing is not one-sided. It is both parties. In this case, the applicants and the state. The state has taken action to implement the orders of court. The orders of court are clear to transfer the files. And it's not in contention that indeed the applicants had been charged at court martial and they had been remanded and there was a warrant for their remand. If the Supreme Court wanted to cancel the remand warrant, it wouldn't have taken a paragraph after almost 200 pages to mention so. It only said transfer the files to ordinary courts. And that's what the state is doing. It would be contempt of court